Good evening, everyone. It's time to start our session. On behalf of the National Legal Rights Consortium and Ages of Women's Indian Chamber of Commerce and Industry, I extend a warm welcome to all of you to this crucial webinar on legal challenges in hospital administration, navigating regulatory complexities. I am Akshaya, your host for today's session, and I'm thrilled to have you with us. The National Legal Rights Consortium has always strived to bring meaningful discussions to the forefront, and today is no different. Hospital administrators, healthcare managers, and legal professionals all play a key role in ensuring that hospitals not only provide quality care, but also comply with complex legal regulations. Our session today will help you navigate these challenges. The National Legal Rights Consortium and the Women's Indian Chamber of Commerce and Industry have come together to shed light on an incredible important topic: legal challenges in hospital administration. National Legal Rights Consortium is a beacon of hope for millions of individuals who seek justice, rights, and dignity in our country. At the core of National Legal Rights Consortium's mission is the belief that legal rights are not just words on papers, but fundamental principles that shape our society. Through advocacy, awareness camps, and legal support, NLRC is working tirelessly to ensure that these rights are not just theoretical concepts, but practical realities for every Indian citizen.
Now, it's my pleasure to introduce our esteemed guest, speaker, Advocate Khushi Makwana. Ms. Makwana is the legal manager at Vasundhara Hospital and a practicing lawyer at the Rajasthan High Court in Jodhpur with a deep focus on healthcare law and hospital administration. She has pursued her BA LLB and a PG diploma in medical laws and ethics from NLSU Bangalore and is currently pursuing an MBA in hospital management at IIHM Jaipur. With her extensive experience in hospital management and medical legal cases, she will share her valuable insights into the legal challenges, complaint strategies, and risk management practices in healthcare settings. Ms. Makwana, we are honored to have you with us today. The virtual floor is yours.
Hello, good evening to all. Thank you for such a wonderful introduction, guys. Thank you. I'll just share my PPT with you all. Kindly bear for 2 minutes. Just a minute. Is it visible to you?
Yes.
So, my topic today is legal challenges in hospital administration. So, what is the critical need of understanding the legal challenges in hospital administration? First, I would like to understand that and make you understand that basically. So, the critical need is that it ensures that the safety and quality of a hospital is maintained. It builds trust and credibility with all, and it ensures accountability mainly, and also prevents chaos as well as minimizes risks and penalties. So, what comes to your mind when you look at a hospital? Just drop a text in the chat box where I'll be able to understand. Good. So, basically, doctors, nurses, right? The first thought that comes to our mind is doctors and nurses. So then patients who run into emergency situations, maybe in pharmacies. Just a minute. Yes. Pharmacies. And we need a cleanliness and sanitization in a hospital. When we enter into a hospital, we want a clean environment. Pharmacies that we can get prescribed medicines from there. Then, of course, a lot of paperwork and administration. Medical equipments like MRI machines, CT scans, and a lot of it basically. So it's not only about this. Basically, in a hospital, everything that I've mentioned, iske piche, there's a whole lot of mechanism, a legal mechanism, HR mechanism, whatever comes to your mind, it is basically regulating all of it. The mechanism, but we have to understand the mechanism behind it, right? And so first we'll start with the major regulatory bodies. That is the Ministry of Health and Family Welfare. So a question comes to mind that why do we need to understand the Ministry of Health and Family Welfare, right? So it's basically it formulates the health policies, and it makes us understand the policies and the programs that are created, and it impacts and how it impacts our access to care. It also plays a key role in public health campaigns and responding to health emergencies. Like in COVID, it helped us making tests available to all, as well as inform the public about the safety measures and helping to manage the crisis effectively. So, and a very like an example that comes to my mind is Ayushman Bharat Yojana, which I guess PMJY, which everyone here knows, Ayushman Bharat Pradhan Mantri Jan Arogya Yojana. So the role of Ministry of Health and Family Welfare is basically to formulate policies, implement health programs that is accessible to all, regulates the pharma and medical devices, promotes research and development, health education and awareness, and everything basically. So now let's talk about Central Drugs and Drug Standard Control Organization, that is the CDSCO. So the main role of CDSCO is to ensure the safety and efficacy of drugs. Just a minute. Yes. So yes, the safety and the efficacy of drugs. This ensures compliance with standards, ensures patient safety, builds public trust in healthcare practices. It regulates clinical trials, monitors, and approves whether the clinical trials are able to protect the participants and ensures valid results. And of course, it protects the public health in a way. It ensures that drugs and cosmetics meet the standards that are set by the national and international standards, basically. And the key act can be Drugs and Cosmetics Act 1940. I guess you all must have heard of it. Next comes National Medical Commission. Earlier, it was known as the Medical Council of India, but later, under the National Medical Commission Act 2019, and it was formed. It is very recently that it was formed. So the role of National Medical Commission is it regulates the medical education, professional conduct, and ethics, and of the medical practitioners, and it maintains a register for all the doctors that are to be that they have to apply, they have to register themselves with the National Medical Commission. It basically also oversees the licensing and the certifications for the practicing doctors, for the practicing RMPs as well. There are 4 boards that comes under it. That is, it basically looks after the undergraduate education, the postgraduate education, the medical assessment and the rating board, as well as the ethical and medical registration board, which is a very important and a crucial board as seeing the current situation. So very recently, the NMC has come up with a unique ID system. Basically it is what happens is National Medical Commission. You all know that we all are going towards a e-world thing, right? So even the NMC has also come with a National Medical Register that will be a dynamic database that will verify the authenticity of all the registered medical practitioners, and using their Aadhaar ID cards. So the very famous national accreditations. So what are the national accreditations basically? Why is it important? It is Important because it ensures that hospitals and clinics meet specific quality and safety standards. It helps build trust between the patients and the hospital, and it also confirms at a certain point that the facility is reliable and it is providing a high quality care. So there are various accreditations and certifications that are given by the Quality Council of India, which you can see that it is for basically everything, be it a blood bank, be it Ayush hospitals, be it eye care organization, medical laboratory, nurses, and of course hospitals, right? So what is NABH basically? What National Accreditation Board for Hospitals and Healthcare Providers mean? What does it do? Right. So it basically sets benchmarks for hospital quality and patient safety. The role and the importance of having an NABH in your hospital is that it improves patient care. It ensures the safety, rights, and quality treatment for your patients. Second is it enhances hospital standards. It encourages continuous improvement in our hospital and the infrastructure and the processes. Obviously it has regulatory compliances to back it, and it ensures that the hospital is adhering to the legal safety and ethical standards in the healthcare that are maintained with the national as well as the international standards. So we'll jump right into the legal framework that we are here for. What are the acts that are to be governed within a healthcare system, right? So there are a lot of acts, there are a lot of laws that govern a hospital, basically. And n number of laws are there from the commissioning of the hospital, from the medical practitioners, the conduct of the professionals, the qualifications, as well as in the management of patients. So you can see that there are a number of laws that a hospital has to go into, right? So first we'll talk about the Clinical Establishments Act. And of course, being in a hospital, it also makes sense because patients are there, the hospital staff is there, the nurses are there, and there's so many things that comprises a hospital, as we saw in the slide, which I showed you, where I asked you that what comes to your mind when you see a hospital, right? So there are laws that are already governing us. I'll start with the Clinical Establishments Act. I will not go into all the acts that I showed you here because it's going to take a lot of time. So the Clinical Establishments Act, I guess we all have heard about this act. So, this act is basically the aim of the act is to regulate all the clinical establishments and provide a set of standard practices that are to be implemented. It also establishes a digital registry of clinical establishments at national, state, and district levels. So we saw that National Medical Commission maintains a registry that is for the practitioners, that is for the RMPs, for the medical practitioners. And Clinical Establishments Act establishes a digital registry of the clinical establishments, that is the hospitals and clinics, right? So it is basically to prevent the quackery by the unqualified practitioners. And in a clinic, in a polyclinic, certain standards have to be maintained. So the standardization of healthcare facilities is provided under the Clinical Establishments Act. It prescribes minimum standards of facilities and services for all categories of healthcare establishments. I'm only talking about the hospitals here and not any teaching hospitals right, as of right now. And yes, basically. So there are important sections that I would like to touch upon very briefly because it is very important for us to understand few sections. I know takes a lot of time. What is the legal jargon? We don't understand it, but at the same time, it is very important for us that we, and whenever anything comes to mind, like, oh, we know about this, right? So the section 12 of the Clinical Establishment Acts talk about the conditions for registrations. Conditions for registrations of a hospital, right? Then the application process and how a provisional certificate will be given to you, and where do you have to display it. The expired registrations are to be published by the authority. So certificate, yes, it is very important, the section 18, that the certificate is to be displayed at the clinical establishment, right? So let's talk about the Drugs and Cosmetics Act 1940 and rules of 1945. So the purpose of the Drugs and Cosmetics Act is the regulations for manufacture, sale, and distribution of drugs and the medical devices. It also legalizes the import, manufacturing, distribution, and sale of drugs and cosmetics. Right? So basically, the Drugs and Cosmetics Act, uh, has regulates the drugs and medical devices, right? So in a hospital where we are constantly dealing with medication, with medicines and other medical devices, so we have to be very much aware about the Drugs and Cosmetics Act because it oversees the imports, that no substandard or counterfeit drugs are to be imported or exported. Then the prohibition on the production of inferior or counterfeit pharmaceuticals. We saw in COVID that a lot of vaccines and injections were replaced, counterfeit products were given to patients, and then again it were sold at a very, in the black market at a very high price. So the Drugs and Cosmetics Act basically oversees that. It controls and regulates the import, manufacture, sale, and distribution of cosmetics, as we discussed. Also, it sees that the standards and the analysis of samples in accredited laboratories to look after whether the drugs and the medical devices are of a such or of a standard that is prescribed by the DNCR. Sorry, I guess I'm not able to share my slide. Just wait a minute. Are you guys able to understand what I'm trying to say? Just put the hands up in the, just react on the chat. I'll be able to understand that everyone is here. Thank you, guys. I just saw the chat. My voice is a bit low. Am I audible now? Okay. Just
Ma'am, you are audible, ma'am.
thank you so much. Just give me a minute. I'll reshare my slide. And again, I would like to interact with everyone, but I guess we have set it up with the on the last at the last, right? So just a minute. I'm still not able to share. It's a little problematic when I'm so sorry, guys. There's some problem with the network or something, maybe. Not able to share my just a minute. Uh, yeah. So let's talk about the Consumer Protection Act. So, the consumer law has indirectly defined what the services are to be governed. Well, let's talk about the Consumer Act first, right? So, this act is designed to safeguard the consumer rights. It ensures the effective resolution of disputes. It establishes dedicated authorities to see the fair practices and to protect the consumer's interests, right? And now the question arises, who is a consumer? So basically, a consumer is a person who buys any goods or services for a consideration, right? So, I'll just read the definition for anyone who is interested. So, a person who buys any goods or services for a consideration which has been paid or promised, or partly paid and partly promised, or under any system of deferred payment, also includes the user with approval of such goods or beneficiary of services. Right? So, the question here comes that how does healthcare services fall under the Consumer Protection Act, right? Because we are, from our understanding, a consumer is we walk in a mall, we get something, it comes expired, we file a complaint in the consumer court, right? So how does healthcare services are coming under the Consumer Protection Act? So it is a very famous case. I don't know how many of you are aware of it. The Indian Medical Association versus VP Shanta. So in this particular case, I'll not go into the details, but I'll briefly explain it to you that what was held. The medical service, the Supreme Court held here that the medical services were equated with the commercial services. The doctor-patient relationship was declared to be a contract for services, and the patient was now a consumer, a client who has paid a consideration for I'm again enunciating on the word for. The services and the treating professions were just body mechanics, these that comes under the service vendors, right? So it happened in 1995, and the Consumer Protection Act in 1986. It was also included, but like not included per se, but later on in the Consumer Protection Act 2019, there were initially a draft which included the healthcare services, but it somehow it got dropped in the final version when it came to when it was amended in Consumer Protection Act 2019. There was no mention of healthcare services. So, the consumer, as I said, is a person who buys any goods or services for a consideration. So, here in the medical services, a consumer is a patient or someone who has come to the hospital paying a consideration, and here the hospital has become a service provider. All right. So, yes. So basically, now the services are divided into contract for personal services and contract of personal services. So in the act, the contract for personal services are to be covered under the Consumer Protection Act, not the latter part. So the contract for personal services, it includes the skills and discretion, that is the doctor-patient relationship, and the contract of personal services is basically chauffeur or an employer thing, right? So I hope everyone is clear on this. Okay. So now I'll directly jump into the major legal challenges that are faced by healthcare nowadays. So, why do we need licenses and certifications? We saw that there are so many acts, then there's national accreditations as well. Why do we need all this, right? So basically, a legal compliance, it ensures that we are operating under the laws, Indian laws, and we are able to avoid the legal penalties. And of course, it makes us, the hospital has standards of quality. So we are able to assure the quality of services, the credibility and the trust, the operational efficiency of a hospital to promote better resource management and operational practices, and also patient satisfaction, which of course leads to higher patient satisfaction through improved quality of care when we get a license or a certification or a national level accreditation, right? So yes. So now when we are in a hospital, when we are commissioning a hospital, managing a hospital, we'll understand there are so many of compliances, n number of compliances that we have to go through. First, hospital, when we are thinking of a hospital, we have to think about the land. Then we have to think about where to get it, how to get it, the certification and the stamp on a paper that, oh, you can have a hospital at this. इतना दूर होना चाहिए, इतना दूर होना चाहिए. I hope everyone is comfortable with a little bit of Hindi in between. I will try not to say a lot of Hindi words, but then again, sometimes it happens. So, so basically, there are a lot of compliances that a hospital has to go through regarding the land, the buildings, the now. So there are very digital regulations as well, operations like NABH and National Commission Act, as we saw for the medical practitioners. And of course, then there are other acts, that is medical termination of pregnancy, preconception and prenatal diagnostic tests. And there's so many. So, why do we like there are so many so many compliances and these so in number of standards that we have to adhere to, be it national, international. So I'll just drop in a few examples like licenses and registration. We talked about the Clinical Establishments Act. It mandates the registration of hospitals, ensuring basic standards of care. And at the same time, in the international requirements, it is adherence to the Joint Commission International, which are the standards for quality and patient safety for accredited hospitals. We don't have to go into that because abhi will focus on the Indian standards only. So I'll just cover up the topics. So the licensing and the registration, be it the patient safety and quality of care, the biomedical waste management, ethics in human rights in healthcare, that is the Mental Healthcare Act, and basically the Universal Declaration of Human Rights. It talks about that no person should be to not have that I can't go to a hospital or I'm not able to secure a good medical facility or the हम यहाँ पे गए हमको वहाँ पे मना कर दिया for the medical services. So this somehow covers under the UDHR also. The ethical standards that are to be maintained with the patient care. Then it comes with the clinical trials and research, environmental and safety standards, medical devices and equipments. So basically, in India, the hospitals have to continuously align with both the national and international standards to see whether a hospital is legally compliant and is thoroughly having patient safety and quality and providing a quality of care or not. So as you can see, they are in again the license and certifications that are required for hospitals are and have to be renewed again and again. Some are monthly, some are annually, some have if you have come with a registration. So like just for the initial part of it, we need that, and some are to be renewed after 5 years, 3 years. So basically, these are all the licenses and certifications mostly that I've covered. Then comes the AERB. So what is AERB? Atomic Energy Regulatory Board, which comes under the Atomic Energy Act. So it is for the CT scan machines, the sonography, the radiology machines, and the MRI machines and everything, because they have the radiation that comes through it. So to have those machines, you have to get a license from the AERB, so that we are able to put those machines in working at a hospital. So it ensures radiation safety and protects the patients and staffs again. It enforces regulations to protect patients, healthcare workers, and the public from harmful exposure to ionizing radiation, right? Then again, what if the machine, the equipment that we have got is not compliant? We have to the machine that we're getting should also be. We have to also ensure that all the radiation equipment meets national safety standards and operates within permissible limits. It is crucial, and I'll again say that we think that AERB or BMW Act and the Fire NOC are just basic certification and licenses, but then again, we have to continuously go through them again and again. So I'll just talk about this first. So ARB's permission is crucial for maintaining a safe environment in the healthcare facilities that are using the radiological technology, that is the CT scans, X-ray machines, and everything. Yes. So biomedical waste management. Why do we need a biomedical waste management? Right? It is to prevent the environment from being a reservoir and a vehicle for the spread of microorganisms that involves hospital-acquired infections. So I'll again give an example of COVID-19, because we saw at that time how we were disposing our stuff, how like the PPE kit we used to wear, we used to again dispose it in another, like segregate it with from the other waste, right? The injections, the gloves, and everything, we used to segregate them, taki the infection is not spread in be it the hospital, be it the staff, be it anybody. Right. So, the BMW, the purpose, the Biomedical Waste Management Act, it helps us to guide the handling of contaminated solid and liquid waste material. And they have also given a very good segregation of the infected waste, the non-infected waste, the dustbins that are basically given, which I've shown here, the red, yellow, blue, and the little red box and a yellow and a green colored bin is for basically general waste like paper and food stuff. So why fire NOCs? We all have heard about fire NOCs. So why should a hospital adhere to a fire NOC? So, the National Buildings Code and the local fire safety laws have to be adhered by hospitals, because if not, and a fire breaks out suddenly, how are you able to define and defend yourself that, oh, we had no idea that a fire NOC was to be taken, a license, a certification has to be taken for that. So in every hospital, you will see that there are fire extinguishers, fire exits, labeled very particularly in very big bold letters, right? We have also seen a lot of news recently about a fire that has been breaking out in hospitals. So recently, a fire broke out at a hospital in Delhi, a neonatal care in this year only, and unfortunately, seven newborn babies expired in that fire. So what basically happened? The hospital was operating without a license, and it did not have the necessary clearance from the fire department. So again, we have to regularly check the nozzles, check the fire extinguisher, and the water pipe that we have in our hospital, that if it's working or if it's not working, because we never know what happens, right? So there are various common hurdles and solutions for the accreditation. Like, people don't know, the hospitals are not aware about the NABH standards and accreditation processes. The documentation is not proper. Of course, the staff is a little hesitant, and they may show resistance and change, because NABH standards have a little strong, they have very strong practices that are to be met. Then smaller hospitals have very limited resources, may lack financial requirements for the accreditation, and after having NABH, we have to continuously, maintain compliance after accreditation can be, of course, be difficult because of the changing regulations. So now they are the rising concern of the NABH, getting it fraudulently. Because after when we see a NABH logo at a hospital, we uh, are always like, we feel that okay, this hospital has a government accreditation, and it is be it a private, it is a private hospital, plus it has NABH accreditation, so it will provide a quality of care, right? But be very mindful that if we, uh, you know, I'll say, please never engage in a fraudulent act of obtaining a NABH, just because it gives a hype over the other hospitals, but it's not good, because it will again lead to very serious legal troubles and damage the trust in the people as well as the healthcare facility. Then we'll talk about consent. So we all know consent, right? It is a document that ensures you know, an ongoing communication process between the patient and a healthcare provider. So there are legal requirements for obtaining a patient's consent. That is, first is informed consent. It implies that the healthcare provider has given information about the patient's condition and treatments or treatment options, and that the patient has used this information to choose the option that he or she feels is right. And obtaining informed consent in medicine is a process that should include that, to describe the intervention and emphasize the patient's role in the treatment and in the decision making, and of course discussing the alternatives, and yes. So the consent is to be should be given freely without any pressure or influence. The capacity to consent is 18 plus and with having a sound mind. Then again, when we talk about Mental Health Care Act and other acts, they have a little, they also have defined capacity to consent, which regarding their acts and the suitability of the patient. But yes, 18 plus is a legal age, is major. So that is the one rule of the capacity to consent. Then the consent should be written, that is required for surgeries, invasive procedures, and high risk treatments. Emergency situations, we can see that the patient is not able to consent, and it is implied in those cases. Then there are there are three types of consents. That is a general consent form, which can be against the for the admission and discharge against medical advice. Do take that. The procedure specific consents, like if the patient is going through, say, any surgery or MTP. Then a practice that I think hospitals should also start having is the financial consent forms. Basically, for the third party and the empaneled patient, it is very necessary for you to make them understand the financial things that are going to come through, because a lot of them don't know about it. And they don't know what the insurance is covering, what it is not covering. So you have to make them understand that this XYZ insurance only covers this part of the medical procedure, and other than that, you will have to pay. The rooms are of this cost, and your uh, insurance company or your government scheme is only giving you this room. So you have to make them understand, and then again take it in written. And in high risk cases, take a video consent, because it is very, very, very important in today's practice. We never know, a high risk patient comes in, and then at a very later age, when the health starts deteriorating, they will again come and say ki, we were not informed about it, we had no idea that this is going to happen. So it is better if you take a video consent. Of course, please adhere to the legal guidelines of it. So ensure that there's a clear communication in the consent forms. Use a vernacular language. Don't just write medical jargon, because a layman will not understand what the medical jargon is, basically. So, and provide the entire information. Explain the diagnosis, treatment options, the risks, and the benefit of going through the operation. Plus, confirm that the patient have understood what he or she is trying. Confirm that the patient is able to understand why are we taking the consent form. Use written consent, as I have said. Plus, allow them to have a sufficient time to absorb all the information, right? So I took a consent form for the admission in a hospital. So just um, look at the signs. Okay. So the name of the witness, that is the attendees. Take the signature of the attendees. Also, take it in writing from them as well. Not if they don't understand English, please keep a consent form in a vernacular language as well. Keep two consent forms, basically, each for the attendees as well as for the patient, and take the signatures, the time, the age, everything, basically. Then comes the medico legal cases. So, what a MLC is? A MLC in a hospital is where a doctor believes that a law enforcement should investigate to determine who is responsible for an injury. Right? It may include the assault cases, the domestic violence cases, the substance related incidents, a motor vehicle incident, and unnatural deaths. Right? So, what do we do when a MLC comes? There are general guidelines for dealing with a medical legal case, that is, resuscitation and stabilization of the patient. Yes, so resuscitation and the stabilization of the patient is the must be the priority of the hospital. Medical legal formalities can, of course, can follow, but the stabilization of the patient is a first. Then again, the consent for treatment is implied in emergencies. The documenting of the MLCs, do it very properly, maintain a MLC register, inform authorities, police authorities, that on the arrival of an MLC, say in an emergency situation, a doctor is there, any staff, be it a manager, be it the reception staff, call the police authorities and inform them that that a MLC has come, and this other things. In many cases, we will not understand, we will not get to know the name of the patient. If you could please stop scribing on the PPT, it gets a little distracting. I'll continue. Then confidential records. Medical legal documents are very confidential, right? It should be secured, stored in a very stored securely, and it should only be accessed by an authorized person. That then comes the patient rights and privacy. So, a patient, what are the rights of a patient, right? So, right to information, to emergency care, to informed consent, confidentiality and privacy, non-discrimination, right to transparency in rates, right to a second opinion. If a patient feels that I have come to a hospital, I have discussed my problems with a doctor. So the doctor or the medical practitioner or the hospital cannot say, कि you came here first, now you can't go to another doctor. No. A patient always has a right to second opinion. They can go to another doctor, take a second opinion, then maybe come back to the first one, right? Or may even go to a third doctor as well. So in the Indian legal perspective, I'll say a patient goes to 4 doctors and then goes to a doctor who is known to their family. So, and a right to choose treatment options, right? So confidentiality of patient information. The practices to safeguard patient information that nowadays we are using hospital management systems. So take care that that ensure that the compliance with data protection regulations is there with the hospital management systems, and it complies with the Information Technology Act and provides us features like encryption, access to controls, and audit trials. Okay, audit trails. So the data encryption and security, it protects the patient's information through encryption and secures data servers with firewalls. Then again, training and awareness of the same has to be given in the to the employees, and the incident response and backup plans must always be there, right? And yes. So, in 2022, AIMS had to face a cyber attack. So, AIMS in Delhi has like the patients that come there are high profile patients. So when a cyber attack like this happens, and the server of AIMS was blocked for almost 2 days, 3 days, I guess. I'm not sure, but it got locked, and the database and everything was corrupted and hacked. So you see, the high profile patients are there, and there are so many people whose bank accounts, everything basically was hacked. So it became a privacy concern, and there was also a possibility of patient data being compromised, right? So Supreme Court, and it went everywhere. But then again, AIMS, with the help of CBI and a lot of other mechanisms, it tracked its way back and were able to again take the hospital database again. So, and again, it happened in 2023, that is last year. But AIMS Delhi was prepared for it this time. It successfully was able to overcome and neutralize the threat. So, the hospital has to be prepared for these things as well. We never know how digitally we can be compromised as well. So we have to be on our feet that anything bad can happen at any point of time. Then comes the PCPNDT Act 1994, that is conception prenatal diagnostic tests. It came and it is an act to provide for the prohibition of sex selection, right? It came to prevent misuse of such techniques for sex selection that leads to female feticide. So the clinics must register under the Section 18 and renew the registration every 5 years. Consent and disclosure, again, consent is very important here. The records must be maintained, proper forms are to be filled, a sign, clinics are required to display signs to create awareness that sex selection is prohibited. You must have seen these signs in sonography rooms or when you enter into a hospital, right? So we'll move to medical negligence. Somewhere I read a chat which asked me how to not have medical negligence cases. Well, in today's scenario, we never know. But then again, I'll again talk about this. So, medical negligence refers to a situation where a healthcare professional fails to provide the standard of care that is expected in their field, leading to harm or injury the patient. This could be due to errors, omissions, lack of proper attention during treatment. So it's it is we have seen a serious rise of medical negligence cases in the last decade. Although it is a noble profession, but it is still not immune to criminal cases, to civil cases, to consumer cases. So, what basically is medical negligence, and how does it occur? So, there has to be an existence of duty that exists between the doctor and the patient, right? That is the dependent and the complainant. So, where there's a duty, the doctor has to fail to meet the legal where a doctor fails to meet the legal standard of care constituting a breach of that duty, right? Which results in damage. Damage must be resulted from the breach of duty that exists between the two and is recognized by law as suffered by the patient. So, the practitioner must bring to his task a reasonable degree of skill, knowledge, and must exercise a reasonable degree of care. Okay. So, just a mere deviation from normal practice is not necessarily evidence of negligence. To establish negligence on that basis, it must be shown that there is a usual and normal practice, that the defendant has not adopted it, and that the course, in fact, adopted is one no professional man of ordinary skills can be taken. Okay. So in India, we practice Bolam test. So what is a Bolam test? A Bolam test is that a doctor is not negligent if they acted in accordance with the accepted practices of a responsible body of medical professionals. That is, if he is bringing a reasonable degree of skill and knowledge and exercising a reasonable degree of care that is accepted by a body of medical professionals, the doctor is not negligent. It was very deeply discussed and enunciated in Jacob Matthews versus State of Punjab case, which is very important, very crucial in the Indian sector. So the Bolam test was came from the McNair's J. N. Bolam versus Prime Hospital Management Committee. So it is very easily, it was held in the, it was observed in the Bolam versus Prime Hospital Management Committee that where you get a situation which involves the use of some special skill or competence, then the test as to whether there has been negligence or not is not the test of the man on the top of a Clapham omnibus because he has not got this special skill. The test is the standard of the ordinary skilled man exercising and professing to have that special skill. A man need not possess the highest expert skill. It is well established by law that it is sufficient if he exercises the ordinary skill of an ordinary competent man. Okay. So, new criminal laws are here, uh, replacing the Criminal Procedure Code, the Indian Penal Code. So, in Bharatiya Nyaya Sanhita is 2023. And we'll talk about the new sections that are included in the criminal laws against the RMPs. So, if a death is caused by negligence, a registered medical practitioner, while performing the medical procedure, if causes death, then he shall be punished for a description of 2 years and a fine. Then they have also explained what a registered medical practitioner is. It means a medical practitioner who possesses any medical qualification recognized under the NMC Act 2019. And then again in 120, section 125, an act endangering life or personal safety of others. It is discussed the rashly or whoever does any act rashly or negligently as to endanger human life will be punished with an imprisonment for a term of 3 months plus the fine. So, how to avoid medical negligence lawsuit? Well, in today's world, as you can see in the picture, that law has an inclination towards the public, the patients. In this thing, how a doctor, how a hospital can avoid a medical negligence lawsuit. So there are 7 hours that one has to take care of. First is rapport building. It means that the doctor should use all the reliable and the relevant information to make diagnosis and to formulate the treatment. Then there's rationale. Rationale is okay. So the rationale is the one where the doctor has to use all the relevant information, and rapport building is we know the effective and the verbal communication that is to be maintained. Then comes records. Records records are that should be maintained and be carefully prepared, completed, accurate, and relevant to what is given. The record will be the most important evidence, regardless of all the facts and the standard of care practiced. So please keep your records, your documents very safe and very extensively, made. Then comes remarks. Do not disagree with the patient and his family when it comes when they are being very violent or aggressive. Don't disagree with them. Instead, take do not criticize them. Basically, of course, we have to disagree with them on certain points, but don't be very violently, aggressively criticizing them. Oh, ye nahi waise. Don't do that. It can anytime come back at you, right? Then comes respect, which comes with the remarks thing that you have to respect, have an attitude of care and concern, right? Uh, then comes risks. The patient and the family must be informed of all the anticipated risks while performing the treatment or operation with the consent forms, of course. And also, you should be able to understand what the treatment is about and what are the risks that can be. Then review. So it is to be routinely review cases involving morbidity and mortality, review medical malpractices cases and the testimony of medical experts so that you are well aware of what is going around and what can happen if anything goes wrong, what can happen, how can we avoid it, basically. So we'll talk about the risk management strategies. Um, I think I'm reaching my time, so I'll just wind up. But right? But I'll cover my entire PPT, so don't worry. So, medical records, the ownership and the confidentiality of a patient comes through the medical records, right? It is the property of the hospital for the patient care. So, it belongs to the patient but cannot be shared without consent. The patients may have full access to their medical records, but when there's a medical case and the relatives come barging in that we want the medical record of of the patient because we are related to them through XYZ, and don't don't provide the unless it is needed by law. Okay, have written request details, proof of relationships, everything with you. And then again, the OPD records and the IPD records are to be kept for a certain period of years. And then when you discard them, maybe after 10 years, when you discard them, you have to make it public that these we will be discarding the medical records of, say, 2015. And if anyone wants to know about something or something, contact our hospital. Um, few legislations also have statutes also have a description of how many years the medical records are to be kept, like in ART. Even after you shut down the hospital, you have to keep the records with you secured, and then maybe if you are shutting the hospital down, you have to give it to the authority. Then professional indemnity insurance for doctors, very important. Why? Because it is an insurance protection against claims of medical negligence that covers the legal expenses and compensation. We know that uh, you know, legal expenses can go way up, and when compensation has been asked, we how are we able to give that sort of compensation, right? So that is where the indemnity insurance comes. It basically it gives a financial protection to you, and it is needed by all medical professionals, doctors, nurses, technicians, basically, but it is mostly for the doctors and hospitals, right? And the Prevention of Sexual Harassment Act 2013, and now there's an amendment also in 2024. With the very recent and unfortunate event that happened in Kolkata, it is very important that we also take care of posh policies in our hospitals as well, in the healthcare systems as well. Not only in the healthcare systems, but in any workplace environment. It is very necessary that we take care of it. So we constitute of the responsibilities of the employer under the act is that they constitute internal complaint committee to handle the complaints of sexual harassment, display the members of ICC, as well as display the penalties and consequences of sexual harassment. Okay, provide a training and sanitization of the employees on this. The amendment in 2024 talks about the extension of the time limit for filing a sexual harassment, which earlier was 3 months and now it is 1 year from the date of incident. So then comes staff regulation. Staff is a very important body of a hospital. Without them, the hospital is just another building, right? So it is very important that we adhere to the labor laws and the regulations. It prevents us from having legal disputes and protects the employees' right? The HR has the main responsibilities on staying informed on the laws to monitor fair treatment and safety and to protecting the employees' rights. There are n number of laws again which governs the employment and management of manpower, and that is staffs. Um, for the compliance stuff, I think that the standard operating procedures and contracts are very much needed in today's environment. SOP is it provides very clear and step-by-step guidelines for the hospital staff to follow, and what role they are going to be in. And it also plays a vital role in managing the crisis, the patient care protocols, service managing the maintaining the service quality, and then again, of course, minimizing the legal liabilities as well. The SOPs with the staff, it helps in reducing the human errors, streamlines the operations, and enhances the compliance with regulatory standards. Employee contracts are to be signed with everyone that is hired and onboarded, be it a doctor, be it a nurse, be it a technician, be it anything. Okay. So, because the contracts define the legal relationship between the hospital and their employees, it sets out their roles, the responsibilities, the expectations that we have, and of course, terms of the employment. So for hospitals, it is very essential that both medical and non-medical staff is aligned with the with the goals of the organization and adhere to the legal obligations as well. So, when there are many disputes that that comes in with the handling of the employment, right? There may be workplace harassment. We talk about the POSH. We create a ICC committee to to go through with a grievance. It's a grievance mechanism, anti-ragging. Then again, the contract disputes can happen. So it's very important that we clearly define the job roles. Then sometimes it becomes that where there are corporate hospitals, strikes may also happen with the staff, which is very well discussed with the Industrial Disputes Act. And yes, so I'll start with the compliance strategy initiation and how to manage the risk. So first, the HR team, the quality manager, the CSO, everyone should establish a compliance program. Create a compliance team that only that is only focused towards handling the compliances and the regulatory staffs, and and develop the policies and the procedures and how you will mitigate through it. Then regular training and education must be provided, be it workshops and e-learning, everything. The uh, staff should, because while working, you forget certain things, right? Although we don't expect the staff to forget, but they will. At a certain point, as a human, they will. That is why the regular trainings and workshops are to be conducted. Then monitoring and auditing, very important. The routine audits must be done, the data analytics for trends, for the recent trends that are going, the recent developments that are happening. Then there must be proper reporting mechanisms in place which establish a confidential reporting which encourages transparency. Then comes the engagement with regulatory bodies. The you know the regulatory bodies can be, if we talk about the NABH, we have to be very well versed with the what NVH is, the who is coming, who is not coming, then be the fire NOCs के लिए when regulatory bodies are there, have to be very stay updated on it basically and see guidance from them. Yeah, how should we move forward? What all changes we can done? What are the NCs? Then the risk assessment and management. Conduct regular risk assessments, develop an action plan for the risks that you think that can happen, right? Then the patient engagement and communication. As we discussed in the consent, that how to obtain a consent, it is very clear that when we are engaging with a patient, when we are communicating with them, we have a very, we have clear communication. We are saying very limited, but it is clear to them as well that what we are trying to communicate. And also have the feedback mechanisms because it is going to help you grow. It will make you understand where you are lagging and what all you can do to grow. So they need technology utilization. It is very necessary because nowadays everything, the health records are also going electronic. So it is very important that you stay updated, and even the compliance team to stay updated on it. So use electronic health records, use health hospital management systems for the compliance, and there are a lot of software that can be used for the compliance. Then also plus yes, as we talked about the aims cyber attack, ensure data security. Okay. Collaboration with legal experts, consult legal professionals for contracts and for compliances and wherever the legal lagunas are. Be keep in touch with them. And then performance metrics and reviews. Develop a compliance system, regularly review them, and after everything falls in place, again review your strategy. See whether it's working with a timeline or not. If not, review it, redo it. So I have almost reached to the ending of my presentation. So I'll like very I'll say the takeaway points that you should be applying to your hospital. That is, first of all, go paperless, because as I said, that everything in today's world is going towards electronics, going towards the technology. So embrace digital records, embrace electronic health records and AHS. Keep yourself updated, and also don't forget to have a good backup of it. You can just keep a backup, because you never know what if something like a cyber attacks happens, and what if anything can happen. So just keep a backup. And then again, keep yourself updated with the latest guidelines, evolving laws to stay compliant, and monitor the renewal of licenses and certifications. You can use a compliance software there. Then indemnity insurance, protect like have your practice very, because medical practice is very, you never know. So protect it with a comprehensive indemnity insurance, because we may face unexpected challenges at any point. Then keep a lawyer on hand to navigate any legal complexities that may arise. Get consent for everything. Get clear consent forms. Ensure that there's transparency, they are lengthy, but again, very clear and in vernacular language. Communicate it and collaborate, foster like strong communications within your team, because your team is going to support at the end. Wherever you lag, wherever there is a complication, the team is going to be there. So have a good, strong communication within the team. Have solid contracts and SOPs as well. Plus, patient confidentiality is a fundamental principle, so take care of that. Then understand the patient's rights and duties. Educate the employees as well. So we have seen how a milk, all of us have boiled a milk, right? So when ekdam say we look away and the milk starts overflowing, right? So in that brief moment of distraction that causes the huge mess, hmm, and we all know this, and yet again we all have been there as well, right? So just like that, hospital management, hospital planning, um, compliance adherence, as well as the renewal is quite similar. We think we can handle it later when the time comes, but just like the boiling milk here, by the time we notice it, we could be facing unnecessary expenses or gaps which can catch us off guard. So, what did we understand in the last 40-45 minutes? That don't wait until things are boiling over to take action. A little attention today can save a lot of headache tomorrow. Okay. So I have, you all can take a screenshot maybe if you guys want to read, for if you are interested in reading the healthcare laws, the medical negligence, and everything that I understood. Okay. There are few important cases in the medical negligence field. I know I didn't stress upon medical negligence a lot, but these cases are the foundation of it. And going through it, you will understand how medical negligence law was, taken um, from the ashes. So thank you so much for having me. And I don't know how well I did, but I'm sure I could give my perspective to you guys.
Thank you, ma'am. It was very informative, and I think all the participants liked it. So now it's time for our Q&A session. Uh, Participants can ask the questions in the chat box, or please raise your hand if you wanted to ask verbally. Me and Bhavitra will moderate the session, so please. We do have some questions. So, yeah. Aren't the records the responsibility of hospital? What if in a case the doctor on call is being held liable for not maintaining the record? What should be done in this scenario?
I didn't get the question. Could you please repeat it?
Ma'am, the participant have asked that, aren't the records the responsibility of the hospital? And what if in a case the on-call records or the doctor is being held liable for not maintaining the record? What should be done in this scenario?
So basically, the records, if there's an is I didn't quite get the question, but still I'll try to answer, and do tell me if I'm wrong in answering the question as well, okay? So the on-call doctor, right? So basically, when a patient comes to the hospital and is can be maybe IPD, or maybe have maybe OPD, maybe have it, maybe they come in the emergency section, and there's an on-call doctor. So whenever a patient comes, we anyways have to take the minimum requirements, what the name and everything, right? So that are the records. We have to anyways take them. If we don't have the records, it is not about the on-call doctor, but about the hospital generally. From what I have seen and from what I have read, Abhi tak, it's more about the hospital and not the on-call doctor. Yes, there can be a deficiency of service from the hospital side or from the doctor's side, but then again, the hospital will be made liable because it did not keep the records safe. So, in any case, when a patient comes, you have to take their information, the consent forms, and the financial consent forms later on, of course. But yes.
The next question is, ma'am, can you please explain the active euthanasia and passive euthanasia laws and the provisions?
I wish I could, but it is a very different topic, and we have to connect with me. We'll take a good lengthy session on that as well.
Ma'am, in the chat box, one of the participant asked that though we know laws are there in regards with the right of patients, but how can we make those laws as an acceptance in those hospitals where medical negligence cases are too high and where patients are also discriminated on the basis of their status? What social measures can be taken to ensure the rights of every patient? Should I repeat?
Very good and very very good question. So basically, all the doctors and the patients are, uh, the doctors and the medical staffs are very well versed with the rights of the patients. And if they are not, they are to be educated about it. We working in a hospital cannot discriminate a patient upon their social status or their cultural status. But then again, as a doctor, as a medical practitioner, or working in a hospital, we sometimes feel that, oh no, this is going to happen, that is going to happen. But then again, we have to patient safety and the quality of services that are to be provided to the patients are to be kept here, and our what perception we have are to be kept here. Because even when a doctor comes into the practice, they take a Hippocratic oath. That is, they will help they will help the patients. Yes, there can be legal challenges, there can be social challenges, uh, but your team is there, your legal force is the lawyers, the legal force that you have is going to be there. So, you have to take that in mind. I hope I was able to answer both of the questions. I just keep giving me hands, like a thumbs up if I was able to answer them, okay?
We have more
Ma'am,
questions, ma'am.
we have more questions. So the next question is interdisciplinary collaboration. How important is interdisciplinary collaboration between legal teams and healthcare professionals in managing hospital legal challenges? And what practices can you suggest?
So, as I discussed earlier, that the number of laws that a hospital has to adhere to, a number of acts that are the hospital staff has to adhere to. So, because the acts and the laws, the guidelines, the policies have a lot of legal jargon in it, legal language that no other person is able to, comprehend, to fill the gaps in between. Because even in the compliance team as well, there comes a document. Seven people of us will take it in a very different way. And when it goes to the eighth person, the same line will have a very different meaning for that person. So that is why a legal team has to be kept in the healthcare system, because it will make you understand the legal, the legal possibilities and the legal lacunas that we are facing in a hospital.
Uh, Ma'am, the next question is related to MLC. The participant is asking whether MLC to be can be filed in consumer court or criminal court.
So the MLCs that I talked about was medical legal cases, or the medical negligence cases that you're talking, because the both of these things are very different. So I guess the participant has asked about the medical negligence, and the liability, right? So basically, medical negligence can be, you know, there are three types: civil, that can be filed in the consumer courts, and there can be filed in the criminal courts as well. And both have, it's like different things that can be governed in that, basically. So yes, in both, in the consumer courts as well and the criminal courts as well, both.
The next question is in malpractice of health service, doctors or administrators who will be like responsible in this case?
Very good question, and it is becoming a very tough for the healthcare industry as well to answer that. Not to answer that, but to mitigate that, because there's always a tussle between the doctors and the hospitals that who is going to pay for what. So, when it comes to the consumer cases, the hospital will be liable, because in a hospital, the hospital is said to be a service provider industry and not the doctor. Because as I told you very extensively, that the contract for services are only made with the hospital. And in criminal cases, you can always file a complaint, a suit against, a complaint against the doctor as well as the hospital. But yes, majorly the doctors.
And, the next question is in case of medical negligence, what are the remedies available against hospital or medical practitioner?
So, as such, no remedies per se, but of course, the doctors in the hospitals can always have a legal team that can help them through it. And then again, there are civil remedies that are available, there are criminal remedies that are available. But in a world where we are living today, in a world where every person is turning against the doctors, the only noble profession that we have left, the criminal laws as well, as I said, Bharatiya Nyaya Sanhita has also defined the RMPs. And in the old criminal laws, there was no definition of it particularly. What was the need of defining a RMP? If you're doing that, you should also have a good law, good protection, like law on protection of doctors' rights as well. So as such, the legal remedies that are available to doctor are only the civil you know civil and criminal remedies that are available to generally everyone. But yes, please have a strong legal backup team, because it is very difficult. It becomes very difficult for for a doctor as well as for the hospital, because there's a lot of medical jargon there, and uh, patients thinks that okay, this XYZ thing happened, so it is because of a doctor. They confuse between a medical accident and a medical negligence. So yes, have a good legal backup team.
And
The next question I would like to ask is, so recently the section 304A of IPC has been replaced by section 106 of BNS. And in regard to such replacement, what might be the challenges that, be posed on the medical fraternity?
So even before the section got replaced, the laws got replaced, IMA had a communication with the Prime Minister as well as the Home Minister, saying that there is no need of deliberating a law against the doctors, because in the earlier criminal laws there was just they just defined what negligence is. But in the current legal laws, they have left all the professionals or all the professions, but only focusing on the RMPs, that are the doctors. So what was the need of doing that, first of all? And when you are doing that in a criminal law, so the negligence is including negligence by RMPs, the doctors don't have a criminal intent to do it. It is a mistake that happens, or at many a times, not a mistake, but certain circumstances are there that makes that happen. There was no need of portraying RMPs under the scrutiny. So yes, of course, the doctors and everyone and the doctors and the RMPs are little are opposing this, because the previous criminal laws, no profession was defined. But in this, in the newer laws, the profession has been defined, and it will, of course, create a negative environment. That even the doctors will question themselves, will ask them 5 times before going through a high risk operation, saying whether be it the operation is also necessary. The doctors will ask themselves, should we do it? What if something goes wrong? So it will directly come upon the patient, because uh, the doctor is not liable. They don't have a criminal intent, but then they will be scared to go through a surgery that is vital for the patient.
The next question, ma'am. So considering the increasing legal vulnerabilities faced by healthcare professionals today, so can you discuss the importance of Protection of Doctors Act?
Yes. So, as I said, the new criminal laws that are coming after the new criminal laws now that are now in force, the RMPs are the doctors are under scrutiny and very high risk because a lot of misuse is going to happen, which is a given. Now that the patients are misusing the consumer laws only, imagine them misusing the criminal laws. Given our education, given the education of doctors, the you know the fees of the medical education, plus you know the starting to the end of becoming a doctor is so tough, has become so tough, and has so faced n number of legal complexities. There is a need of Doctors Protection Act uh, because then the doctors are helpless without it. Who would they turn to? India is already suffering from good healthcare services. Now imagine a country where new doctors are not ready to become, are not ready to come into practice only, thinking that there's that it is becoming very difficult to become a doctor basically. So after the unfortunate incident in Kolkata, now DGHS, that is the Directorate of General of Health Services, nee, I guess I said wrong. So anyway, so DGHS is has also been discussing about a code violet. So there are different codes in hospitals, like code blue, code pink, code yellow, right? So code violet is basically for the protection of doctors and the nursing staffs that can be, can be used in the hospitals. So yes, there is a need of protection of Doctors Act because of the increasing violence and the misuse of laws, the doctors and hospitals have become fairly very helpless in these situations.
Participants, if you have any question, please raise your hand or text in the chat box.
Ma'am, there is a question.
Yeah.
So the BNS talks only about allopathic doctors. So is that not discriminatory?
What talks about allopathy doctors? I'm sorry, I was not able to hear you properly.
The BNS talks only about allopathic doctors. Is
Yes.
that not discriminatory?
Everything about the BNS is discriminating only, So I'll just say that because, yes, it is very hurtful to see that the doctors have come under the scrutiny, be it for the allopathy doctors per se, but yes.
Ma'am, the next question. In malpractice of healthcare services, doctors or administrators will be responsible, right? So then, in the case as answered, who will be responsible for the pathology sector? Because the testing procedure is conducted by the pathology. Uh, Doctors with equipment available there. Yeah.
Yes. So, when there's case of pathology, you will have to see whether a pathology is a third party or is or a or the lab is of the hospital's own, because even the pathology lab sometimes are of third party. They get into a third party with a MOU and the third party comes in. The so basically, it is that. So in that case, also a hospital will be responsible because services were provided by the hospital. If it was a third party, then yes, both the parties will be responsible. The doctor can be responsible only in the criminal cases if they have come up with a test and they have not properly, went through the test. They didn't see the reports properly or misdiagnosed it, because it is very viable that that thing hadn't happened, because given the lifestyle diseases we all carry nowadays. So yes, so basically either it's the third party or the hospital.
I think everybody's questions are answered. There's another question, ma'am. For negligence in government hospitals, is doctors personally, are the doctors personally responsible in the government?
So basically, in that case, the government hospital as well as the doctors are responsible. Now, again, in mostly what I have seen is that the cases that I have seen is basically of criminal negligence in the medical sector per se. So both the doctor and the hospital will be responsible.
I think we can take more questions in the feedback form that will be shared soon. Now, I would like to pass on to Bavitra for vote of thanks.
Thank you, Akshaya, and big thank you to Ms. Makwana for sharing your invaluable expertise with us today. And it's my privilege to deliver the vote of thanks on behalf of the National Legal Rights Consortium. And I would like to extend our deepest gratitude to all of the participants for joining us today and making this webinar a success. We hope the insights shared today will help you navigate the legal complexities in hospital administrations more effectively. I would like to thank our National President, Vaishnavi Murthy, our team of National Council members for being the backbone and leveraging the organization work ethics, commitment, and passion for the citizens to connect heart to heart. Lastly, a special thank you for our organizing committee, moderators, and the technical team for making today's event possible. Thank you once again, and we look forward to seeing you at our future events.
Thank you, Akshay. Thank you, Pavitra.
We
Was
have come to the end of the event, the session. It was very good. So I thank everyone and I hope you all had a great evening. I encourage the participants to share your feedback on tonight's seminar. Your input is invaluable and will help us improve future events. Please take a moment to complete the feedback form that is shared with you in the chat box and, for participation certificates too. Thank you. Thank you, ma'am.
thank
And
you.
please stay back. We would like to take a screenshot of all of you after filling the feedback.
हाँ सर बोलिए हम्म
Participants
Yeah.
who want to on your video, please do. We will take the screenshot now.
I request everyone to fill the form and the session comes to an end. Thank you, ma'am.
Can I leave the session again?
Yes, ma'am.
Yes.
Thank you so much for having me, you guys. You both are very sweet for giving such beautiful introductions and anchoring the entire workshop as well. Thank you, guys.
Thank you, ma'am. I request all the participants to leave the meeting.